All rise. Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Alan Lawson, Chief Judge, presiding. All persons having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. As announced, I'm Alan Lawson. I'm presiding today. To my right is Judge Torpy. To my left, Judge Wallace. They round out the panel. We have two cases on the docket, a criminal and a civil case. In the criminal case, each side gets 15 minutes. In the civil case, each side gets 20 minutes. If you are representing the appellant, let me know how much time you want to try to save for rebuttal, and I'll set the clock so that the light on the podium turns from green to yellow when you're in your rebuttal time. It's up to you to decide to sit down and save time, or if you want to use your entire time, 15 minutes, you won't have rebuttal time at that point. So, first case is TYRELL McClendon versus State of Florida. Mr. Gordon.
Good morning.
Good morning.
May it please the court. Good morning. My name is Glenn Gordon. I represent Mr. McClendon, the appellant in this case.
You're going to need to speak up a little bit for me to be able to hear you.
Yes, sir. May I reserve 5 minutes for rebuttal time?
May.
Section 775082, subsection 10, for the Florida statutes mandates a non-state prison sanction when a defendant scores.
So the issue is whether your client could, let's see, what's the language? Could present a danger to the public, right? Whether the trial judge made that finding.
Yes, Your Honor.
Right.
Correct.
So this is the fellow that apparently doesn't know when to quit driving his car with a suspended license, right? How many? 1, 2, 3, 4, 5 or 6?
I think it was, I believe, 6 or 7, Your Honor.
6 or 7 times he's driving a car
Yes, Your Honor.
when he's not supposed to.
Yes, Your Honor.
Does that present a danger to the public?
Well, I think the dispositive question is whether or not the trial court's written findings present.
Well, the trial judge did reach the findings, right? The trial judge wrote in his order that he finds that your client is going to present a danger to the public, could present a danger to the public. So,
But
you're saying the findings have to be detailed? They have to explain the trial judge's reasoning, or?
just that the trial judge's written findings must establish a nexus between a non-state prison sanction and a danger to the community. And the argument would be, excuse me, that
your client admitted that he's driven on numerous occasions without a license, right?
Yes, Your Honor.
And why do we have that law in the books that says that if your license is suspended, you can't drive? Isn't that to protect the public from drivers who are not qualified to drive an automobile?
Well, even if that is the case, Your Honor, the trial court's written findings failed to establish that nexus.
So you're saying that the trial judge has to explain why he thinks that he can't just say, I find that he could be a danger to the community. You're saying that the trial judge has to explain it in detail. Is that what you're saying?
To some extent, Your Honor, but just
where does it
establishing
say
a
that in the
nexus.
statute, that the trial judge has to explain the reason for his finding?
Well, that is a good question, Your Honor, and to answer that, I would think that there is little guidance for trial courts to determining whether or not a defendant could present a danger to the public, or a non-state prison sanction could present a danger to the public. Therefore, I would be advocating for this court to adopt a set of factors in order for trial courts to enable trial courts.
The statute says if the court makes written findings, now you admit that the trial judge made written findings.
Yes, Your Honor.
That a non-state prison sanction could present a danger to the public, the court may sentence him. So this trial judge said that, right? He said,
yes, Your Honor,
could present a danger to the public. So now isn't the real issue whether on this record that those findings are supported by the record?
No, not quite, Your Honor. I would just rephrase it as
do you
there
agree?
being a
You
nexus.
seem to agree that when a violator has a suspended license and continues to drive over and over and over again, that that could present a danger to the community, right?
To some extent, but that's not listed in.
And this fellow, not only has he got a problem with complying with the driver's license laws, he's also got a problem with cannabis sativa L, right?
Yes, Your Honor, but with respect to marijuana, I don't even see how that would present a danger to the
Well,
community.
he kind of admitted to the trial judge that he's got a problem with marijuana, right? I mean, he's 2 times he's been violated.
Yes, Your Honor.
Because he's smoking marijuana and he's not supposed to. It's against the law and it's a violation of his probation. And he basically said, I can't do the probation because I like to smoke marijuana, right? Isn't that what he said?
Vaguely. He does mention that, he does admit that he has a
So we
chronic-
got a guy that doesn't have the competence, is not legally qualified to operate a motor vehicle, and he also has a problem with marijuana. Doesn't that establish facts from which the trial judge could conclude that the man could be a danger to the community?
The trial court's written findings does not state that, Your Honor. And I'd like to actually point Your Honor to a couple of cases. So, for example, McLeod and Porter, one of which is a 50 CA case, the courts actually ruled for the state, finding that the defendant did present a danger to the public, and it actually specified, the trial court's written findings actually specified reasons why a non-state prison sanction for those offenders could result in a danger to the public. However, in Mr. McClendon's case, the trial court's written findings merely discussed Mr. McClendon's criminal history and his VOP history. There's no indication as to how exactly he presents a danger to the public.
Was there also a battery charge, a prior battery charge?
Yes, Your Honor.
Okay, so we not only have a absolute disregard of any of the laws required operating a motor vehicle, we have the potential for the use of illegal drugs, and now he can't keep his hands off of other people, correct?
Yes, Your Honor, to an extent. I would agree that a battery was committed.
Either it's a battery charge or not.
Yes, Your Honor. Yeah, I agree with that. A battery was committed. However, the facts at sentencing never actually discusses the severity of the battery. Now, we all know that a battery is the slightest of a touch, that it's an unwanted touch.
Well, I'm more concerned about the absolute disregard of the law. 5 driving while license suspendeds. Does that mean 5 times he has to be told you have to have a driver's license to operate a motor vehicle, and he gets 5 passes?
Well, not
The
necessarily.
6th one, when he drives a motor vehicle high on marijuana and then strikes another vehicle and catastrophically hurts or kills someone, is that then danger enough to the society? Shouldn't we be giving some deference to the trial judge, who may or may not have presided over any of these prior driving while license suspendeds or know of the reputation of this defendant?
The trial court should have discretion, but at the same time, the trial court's written findings should actually create that nexus to show how exactly, based on the defendant's conduct and other factors taken into consideration, how that actually presents a danger to the community. Now, we
Didn't that
can
all enter into the violation of probation hearing? The judge presided over that and received all of that evidence and was able to consider the tone and demeanor of the evidence and how it came in during the violation of probation hearing, correct?
Correct, Your Honor, but there was very limited evidence. The only thing that at the sentencing hearing, the state never uttered a word with respect to proving whether Mr. McClendon was actually a danger. And with respect to the battery.
Let me ask you this, so back to the point of what's required in the written findings. I mean, normally in what we see, and this is not confined to sentencing or criminal law, but there are plenty of places in Florida statutes where judges are required to make findings. And there's some that detail that they have to make detailed findings regarding a number of facts. And where they don't do that, the general rule is that the conclusory finding has to be made, and then that the evidence has to support that finding, or the trial judge gets reversed. Where the statutes typically require very detailed factual findings, we don't even consider that on appeal if the trial judge doesn't make it, unless generally, unless the litigant files a motion for rehearing and brings that to the trial judge's attention, that although you made a conclusory finding, the statute requires very detailed findings, and you didn't make those, and if you don't make that kind of motion to the trial judge, then we're not going to listen on appeal when you argue that the findings weren't detailed enough. What we will consider is whether the evidence supports the findings, and so what I'm interested in is why you think this statute is different from the other contexts in which we see this issue, and why we're not looking at the evidence to see if the evidence supports the finding. Where in the statute or where in case law does it say that this finding has to be detailed and sort of lay out the connection or nexus between the conduct and the danger?
Yes, Your Honor, thank you. I would say the building blocks are actually going to be in McLeod, Porter, Reed, and Jones. McLeod actually discusses, both McLeod and Porter discuss or both specify reasons why a non-state prison sanction for those offenders.
I mean, like, I'm looking at your brief on page 14, and you say the Jones court reversed the trial court sentence holding that the evidence was insufficient to support the findings. I mean, that's generally the way we look at it.
That's one of the factors, Your Honor. For example, in Jones, the appellate court mentions that the trial court's written findings, most of which were not actually based on the record. So that has to be one of the factors I was arguing for, is that one of the factors has to be a factual basis in the sentencing or in the trial court's written findings. There has to be a factual basis. The other thing that I would advocate for is also that the trial court has to show what is the conduct that is deemed to be a danger and give a reason as to why it is considered a danger. And we actually have that in McLeod and Porter. The conduct was theft, and also in Porter, the conduct was theft. In McLeod, the danger to the community was actually a pecuniary or economic harm. They also mentioned that.
In McLeod and Porter, we affirmed the sentence, correct?
Yes, Your Honor.
So we didn't address the issue of whether the findings had to meet a certain criteria. We just found that the evidence was sufficient to support the findings that were made, and so we haven't, I mean, those cases don't address the issue that you're arguing, I wouldn't think, correct?
Correct, Your Honor. I believe that the factors are implied in the cases. Looking at the cases as a whole, the 4 cases that I actually rely on, looking at those as a whole, that the only way that the appellate courts, or I guess the logical inference is that the appellate courts must consider those factors in order to determine that the defendant presents a danger to the public. And I would also just point out, so for example, the danger to the community in McLeod's case was he was a threat to property, diversion of police resources from other parts of the community. Also the same for Porter. The defendant caused financial and emotional damage. That was the danger to the community. However, in Mr. McClendon's case, the trial court's written findings are silent as to what the danger to the community is.
You're into your rebuttal time if you want to save some time. You have about 3 minutes left.
I would just conclude with also with the trial court and the Apprendi-Blakely issue. Just that under Apprendi, any fact that increases the penalty for a crime.
Well, you didn't raise that issue below, right? That's not preserved, right?
Well, it is, Your Honor. I filed a motion to correct. It was preserved in the motion to correct, and I filed an amended brief including this argument.
You filed a motion in the trial court?
A motion to correct to preserve the issue. And then also filed an amended brief that included.
This is a plea case, right? Your client waived a right to trial by jury and went, and you're not even entitled to a jury trial in a violation of probation proceeding, right?
If that's the law, Your Honor, then I would guess so.
Yeah, I think that is, right? You're not entitled to a jury trial in a VOP, right?
If that's the law, Your Honor. I'm not entirely sure. I'm not entirely sure. I want to say that at least a couple of the cases that I actually relied on involve one of the defendants pleading out. Actually, yeah, in Woods.
The Apprendi rule in a plea is that if the plea admits the facts, upon which the finding can be made, Apprendi does not require a jury trial. But but this is not only is this a plea, but it's a VOP, right, which is a non-jury proceeding, right?
Yes, Your Honor.
Yeah. Okay.
Thank you, Your
I
Honor.
think your point was that Woods versus State that found Apprendi did apply was a plea case, and what the court said was that even a jury finding on the matters necessary for conviction doesn't relieve the burden if additional findings are required relating to sentencing, I think.
Yes, Your Honor. I guess according to Blakely, the relevant statutory maximum is that which the trial court judge may impose without any additional findings. And here, the trial court can only impose a non-state prison sanction without any additional findings, just according to the statute.
Now, in Woods, which is the first case in Florida and the only case in Florida to apply Apprendi and Blakely to this statute and this sentencing structure, recognize that there are exceptions. One is admissions of the defendant can be relied upon, criminal record can be relied upon, and I guess why wouldn't your client's admission that he just couldn't abide by the law and that he smoked marijuana, why wouldn't those things take this outside of the Apprendi-Blakely requirement?
I believe that that he never admitted to actually being a danger. He does admit just the facts for the entry of the plea, and that's precisely what one of the
But he
things that
admitted
Blakely
it.
mentioned.
He admitted also, I mean, he verbally told the judge that he couldn't do probation, he couldn't follow the law, and he had a marijuana problem, right?
Yes, Your Honor, but he also
Those
suggested jail
facts,
time.
because they're admissions, the trial court can consider even if Blakely and Apprendi apply without a jury finding. Jury doesn't have to find those facts because he admitted them correct.
I'm sorry, could you repeat?
The jury wouldn't have to find those facts that he admitted under Blakely and Apprendi, even if those cases do apply.
The only disagreement that I have with it is just that that he just never admitted to being a danger to the public or presenting a danger to the public. The inference, I believe, is there, as Your Honor has made clear, but I just don't think that he actually admitted to being a danger.
And you have exhausted your time. Thank you.
Thank you, Your Honor.
I don't have any questions for the state.
Then we just ask that you affirm. Thank
Do
you.
you have any questions
No, I
for the
don't.
state? I did want to ask you whether you concede that Apprendi and Blakely do apply to this statute and sentencing under this statute. If the score is for a non-state prison sanction, I think in Woods the state agreed that the Confrontation Clause principles apply.
I think they would apply perhaps in general, but especially not in this case. As you pointed out, this was a VOP proceeding where even if he did not admit to the violation of probation, the judge would then become the fact finder in the hearing, and it doesn't make any sense to then have to bring a jury in to...
I mean, but that's on the guilt issue. I mean, it doesn't, I mean, how does that, I mean, Apprendi and Blakely apply to the sentencing phase.
Exactly. So I think it would only apply to this case if the defendant did not, for example, plea to the violation of probation. Then the judge, there would result in a violation of probation hearing where the judge would be the fact finder, not a jury. So I think in the context of a violation of probation hearing, where the judge is a fact finder, a jury wouldn't necessarily have to come in to then find those additional facts as to a danger to the public.
It's judge-made findings connected to sentencing that Blakely and Apprendi don't allow in certain circumstances, right?
Yes.
I mean, it's not relating to the underlying guilt
Correct.
or innocence
Correct.
or finding a violation or that kind of thing.
Correct.
I mean, it's just sentencing.
But I think regardless, in either way, the judge relied solely on the record and on the appendant's admissions in this case, which, as you said, Apprendi and Blakely then do not apply to.
And there's, even if Apprendi and Blakely do apply, there's still a harmless error.
Correct.
Analysis,
And I
correct.
think especially in this case, a jury could not reasonably conclude that he was not a danger to the public based on his numerous convictions for the same offense, various violations of probation, including the newest violation for a offense of battery.
Okay.
Thank
Any
you
other
very
questions?
much.
Nope. Okay, thank you
Yes,
very
no
much.
problem.
Thank you both.